Brian and I are going to talk about mobile home ownership issues. And this is a topic that I think has a great deal of mystery swirling about it. I certainly don't know everything about the topic, and I welcome questions throughout the conversation today, as well as any comments or experiences that you all want to share from your practice so that we get a better understanding together of the issues that mobile home ownership brings. I see that there is quite a few experienced attorneys on this are in the audience for this panel. So please don't be shy about reaching out via the chat, and we can always take you off mute so you can share your perspective. All right, with that introduction, let's get going. All right, just to put things in perspective, mobile homes are, I think, particularly interesting in Pennsylvania, where we have an economically diverse state, right? We have urban centers, we have very rural areas, and mobile homes play a role for affordable housing in all the areas throughout the state. I do cite here that in rural Pennsylvania, the government has cited 11% of the housing stock as being in mobile homes. And I think that's a pretty significant amount when you think about how often overlooked mobile homes are in our conversation around housing and other resources. Now, mobile homes, come in a wide variety of conditions and values. If you buy a new single wide mobile home, you're looking at, $43,000 or more for the purchase of that property. So, at least in the Pittsburgh region, you can buy, single family homes for that amount. But generally, they are drastically less expensive to buy than building a home or even purchasing a single family home with the land that comes with it. So it does become a very affordable housing option. And that's why it's important for us in legal aid to consider all that and help people navigate the issues that come up with home ownership. One of the first things that I want to look at today is, what is a mobile home? Is it a vehicle? Is it real estate? How do we define that in the legal lexicon, and what are the consequences of how it's defined legally? There's various statutes that define a mobile home. The National Manufactured Housing Construction and Safety Standards Act of 1974 is a federal act that talks about what building standards the mobile homes need to be built to. There really weren't standards before that, and you'll notice in older housing stock built before that, it is substantially lower quality. But since then, the federal government has regulated, at least had a baseline of what a mobile home has to entail to actually go on the market. And that statute's definition is fairly broad. It's not just, your typical trailer. It really is just a property, a home that is built off-site and, and then transported to the property and just placed on the lot, not constructed or put together in pieces like a modular home would be. And that definition from that act is used throughout Pennsylvania law. So, the Pennsylvania Vehicle Code defines a mobile home as a trailer designed and used exclusively for living quarters or commercial purposes, which exceeds the maximum size limitation prescribed by the title for operation on a highway and is only incidentally operated on a highway, whatever that means. But the Vehicle Code also defines manufactured home and just steals the definition right from the federal statute. The Motor Vehicle Sales Financing Act and the Manufactured Home Community Rights Act, two important acts for defining in Pennsylvania what your rights are if you own a mobile home, also steal from the federal statute definition. So that's sort of just the statutory definition. It doesn't, I don't think, offer us much help in figuring out whether to treat the home as real estate or a vehicle. So the courts have created a test, and it's an 8-part test that looks to define what the intention of the parties were at the time the home was placed on the physical real estate, on the property. And you'll see that the 8 different tests are quite expansive. It is a balancing test. I think what is really important for most of our clients who are not going to be able to afford the land on which their mobile home is sitting, and they're mostly locating their homes in on rental lots in mobile home parks, is that a big consideration is, do you own the land underneath the mobile home or not? But when you go through these different factors and you balance it out, you can see it was the intention to make that a permanent structure on the land, to physically permanently connect it to the land or not. And if it wasn't, then it is not real estate. And if it was, then it becomes real estate once it's attached. And that's important for various reasons. It's important for taxing reasons. It's also important for lien attachment. So just to give an example, in the bankruptcy context, you're able to cram down the value of a lien essentially on personal property to the actual value of the property, and the remaining amount that you owe on that debt is considered unsecure. Now, you can't do that with real estate. So if your mobile home is considered to be personal property or a vehicle, then you can cram it down, which is generally a good thing for people who are trying to get out of debt. Same thing with the judgment lien, right? So in Pennsylvania, if you lose your case, say a landlord-tenant case, and you have a monetary judgment against you, that becomes a judgment lien, which attaches automatically under Pennsylvania statute to the real estate you own. If your mobile home is not considered real estate, but instead a vehicle, then this lien does not automatically attach. The judgment creditor would have to go through the execution process to levy on the mobile home itself in order to create a lien. And so a judgment lien is just an unsecured debt if you don't own any other real estate. Since it doesn't attach to your mobile home, and that can be valuable to get it discharged in a Chapter 7 bankruptcy. Now, once you've sort of figured out, okay, we know you live in a mobile home, and all right, you have it located in a park. It's not permanently attached to the land because you don't own the land, or it's not in a cement foundation, etc. So it's a vehicle. Then the next question I think that needs to be answered for people is, okay, so if it's a vehicle, well, how do I prove ownership? What do I get? It's not real estate, so I don't have a deed. No, instead, in Pennsylvania, you have a certificate of title, and the Department of Transportation, PennDOT, is the government agency that issues that title and keeps track of that title. And I think that a lot of people forget this when they're going through the hand-to-hand transactions that a lot of our clients use to turn over property, personal property, right? They don't think, gee, I need to get a title through the government or anything. You think, I got a bill of sale. The person who lived here before and owned it has moved out, and they told me I can move in. I paid them money. But there is another step to the process to officially get your ownership rights registered and get that certificate of title so you can prove that you are the owner. The transfer of ownership process, for all vehicles, including mobile homes, is governed by statute. Essentially, you need to go and complete a form through a PennDOT authorized agent. This involves notarization of the two parties switching over title. So both parties have to essentially go down to the agent together and complete the form. I know some people can arrange to do that without having to both be down at the agent at the same time, but essentially you can't just rely on one party here. You have to have both the seller and the buyer participating to get the paperwork completed, and you have to use a PennDOT authorized agent like AAA to get that paperwork completed. And then essentially the parties, on the back of the current title, sign over the sale, right? Sign over the title, and then PennDOT will issue a new title to the new owner. In terms of any vehicle sale, you have to pay the sales tax. And I guess what I've seen a lot of people do when they actually complete the PennDOT form is say that the transaction is for $1 when it's not, so that they can avoid paying sales tax. But sales tax is owed when you purchase a vehicle, and a mobile home is considered a vehicle for this purpose. The other thing that is important to understand and trips up a lot of potential buyers with mobile homes is that mobile homes are taxed as real estate. So that kind of goes back to, what is a mobile home? Is it real estate? Is it a vehicle? Well, for taxing purposes, real estate taxing purposes, it's actually real estate. And Brian will get into that in more detail in a little bit. But in terms of the sales process, what you need to know is that there is now statutory requirement that the seller produce a tax status certificate from the County Tax Claim Bureau or similar county entity to verify that the taxes have been paid. And PennDOT will not transfer title unless that certificate is included. And so I think people who run into problems where they purchase a property without going through the proper process, one of the big things that trips them up is they don't realize that there's a whole bunch of taxes owed, and that the person selling it was basically unloading to them this property that was encumbered by a tax debt. I will note one thing that has come up before is that these tax status certificates from the Tax Claim Bureau are not always completely up to date. So just because you get the certificate, it says the taxes are paid, PennDOT is fine with that and will transfer title, doesn't mean that a buyer can't be stung by a school district debt that just didn't get reported yet to the Tax Claim Bureau, or maybe they don't report it for whatever reason. And so having a bill of sale that actually specifies whether the taxes are paid, how this property is being transferred is important to cover the buyer in case there are things with taxes or other issues that come up later once the transaction's been complete. I put at the bottom here a little fact sheet from PennDOT that explains the process for buying and selling a vehicle and has a subsection specifically for mobile homes that you might find helpful. Just some best practices to think about when talking to clients who are interested in buying a mobile home or interested in selling their mobile home. One of the things that I always recommend is you get a title and lien report or history from PennDOT. They have a form, DL 135, that you can submit to PennDOT. Anyone can submit this, and they will tell you the basic information of who is the owner, and are there any liens recorded on that title. This is important for people, because I feel like since a lot of people don't understand that a mobile home has a title, they're buying things that, just from the occupant who lives there. They're moving on, they want to sell it. You say, sure, I'll buy that. I want to move in there. But you can't be sure that that person is the actual owner, unless they show you the title, and you get this form to know that even if they show you the title, they might have transferred it, and that someone else might now have the actual title, and etc. So this form is the way to really verify whether there's any liens on the title and who is the actual owner. It does take a few weeks to get it, so that'll stand in the way of someone who's really anxious to get themselves some housing. But I think it's important. The other thing that I say is really best practices is, again, to get that written sales agreement or a bill of sale that outlines, the purchase price and the terms of the transfer, so that you can rely on that, because the PennDOT process and forms, they don't have much. They're more just identifying, from who to who is the transaction being done, or, are the taxes paid, etc. But if you have more issues going on in the transaction, you need a bill of sale to make that clear. Now, that's one way to become the owner of a mobile home, right? Is you buy it from either the dealer, which is its own process, buying a new mobile home, or you buy it from the current owner. But that's not the only way that our clients can get themselves into a mobile home. One of the very popular ways I found, because of the prevalence of people not paying their taxes on a mobile home and losing them in tax sales, is that an interested party can buy the mobile home from a tax sale. So there's, I guess we're not going to get into too much detail when we go through the tax session about the different ways that taxes are, collected, and how the tax process works. But there's essentially, in most counties, they're going to follow Retzel and have an upset sale, and then if no one buys it, it'll eventually, or it should eventually, go to a judicial sale. In between that time, someone who's interested in buying the property can make an offer, a private sale. And if it doesn't sell at judicial sale, then it goes to a repository, and someone can try to, make an offer to buy it out of the repository. The key things to remember is that if you buy it from a private sale, it's not free and clear. So again, I recommend that someone get that title and lien search done with Form DL-135, so they know, if I buy this property, what am I buying? Is there a lien attached to it in some sense? And then there's going to be fees associated with a private sale, advertising fees, and just the general costs of the transaction, which can be expensive. They're probably under $1,000 in most areas. And you can combine with other people, say a group of people in a mobile home park, to lower the cost of advertising if you do it all at the same time. I do find that you can usually get a very good deal on an older mobile home if you offer to buy it in a private sale. And then, judicial sale and anything after the judicial sale. So if there's a judicial sale, you buy it at that sale, or it goes to the tax repository after that and you buy it out of the repository. Now, the benefit of that is that it's going to be free and clear. You don't have to worry about figuring out if there's liens on it or anything like that. But again, there's some fees for advertising and paying for that transaction. But I do find that you get a very good deal. Now, just because you paid the money to the Tax Claim Bureau and got a bill of sale from them doesn't mean that you get title. You still have to go back to PennDOT. And I think a lot of people forget about that. I included a fact sheet from PennDOT, a link there, to help explain the process after someone acquires a mobile home from a tax sale. How do they go about getting title? And it's fairly straightforward process, submitting the right forms with the right documents to prove that you bought the property from the Tax Claim Bureau. The last thing I'll note on how you can acquire title is involuntary transfer of title of a vehicle. This is a court process to obtain title when the person who should have rightful title is unable to get it for whatever reason. So it's not for abandoned property, but if if there's been some sort of transaction that and you think you have the right to the title, but you can't get it from the person who has title for whatever reason, you can go to court. And you'll see there's a link to a Lancaster County pro se packet that explains in that county how to do it step for step and provides some forms. Lancaster County is not the only county in Pennsylvania that offers a very accessible pro se petition and instruction kit for asking the court to involuntarily transfer title. But that can be a very good way to get someone title who already has it, but the transaction to buy it just didn't work out the official way, which I find a lot of our clients end up in that position, right? So those are the three ways, right? You can buy it, you can get it from a tax sale, or you can do an involuntary transfer. And I think this comes up a lot when we're talking about, when a client is actually living in the mobile home and is wondering, well, like, do I own this? Can I sell it? Am I going to get full value? What are my rights? Various situations can come up, say the park's going to close. People are entitled to compensation under the statute regulating mobile home parks, but only if they are the actual title holder, if they actually own the mobile home. So there's various reasons that people will want to actually perfect their ownership in the mobile home. And when you talk to people, if they don't have title, think back to what happened. Did they just not complete the process from the bona fide seller that had title? Can you go back to that person and just say, okay, let's pay the $55 and go down to PennDOT authorized agent and get this done? If that's not an option, but you have a bill of sale or some sort of justification for why you're the owner, maybe just send them to do the involuntary transfer. And then what I think you'll find a lot is when you look at the tax history of a mobile home that's not in your client/occupant's name, is that the taxes have not been paid. And in fact, however they got it, was from someone who had already lost the property in some way by not paying the taxes. And in that situation, I think clients can sometimes luck out in that they're not precluded just because they occupy the property already from buying it from the Tax Claim Bureau. So they should probably be directed to go to the Tax Claim Bureau and try to negotiate the purchase of their own mobile home from the Tax Claim Bureau. Of course, that also begs the question, well, if someone sold you a mobile home without paying the taxes or while providing you title, is that an unfair trade practice? And it might be. If that's the case, then maybe that's something that needs to be looked into as well as a legal remedy for the person if they suffered actual damages. All right, I do want to get on to the tax section. We've already chewed up a half hour with me blabbering on. So I'm just going to run through quickly, some issues about financing of a mobile home. So the Motor Vehicle Sales Finance Act, at least that's what it was called before it was amended and sort of resectioned, but that's what people call it. That is, that act applies to most of the financing for mobile homes, because generally there's some sort of installment payment. And the act, I'm not going to say that it really puts too much constraint on what the bank or the seller can charge the potential buyer. But it does put some restraints on that I think are interesting and should be paid attention to, so that our clients aren't being, taken advantage of. It limits the collection of fees and finance charges to a certain extent. There is no prepayment penalties allowed. So, if someone has a 10-year loan to pay off, and near 9, they have enough money to pay it off, they don't want to have to pay all that interest for a year, there shouldn't be any penalties associated with paying that off. If there's going to be a default, then there's the right to cure. Before repossession, a very specific notice is required, and attorney fees are limited. After the legal filing is made, you're looking at reasonable and actual incurred, similar to Mortgage Act 6 stuff, and then same prior to taking legal action. Attorney fees are capped at $150, which is very little, and they're not to be incurred until after that 30-day notice of default was sent. So just like mortgages, there's some opportunity there for unscrupulous lenders and people collecting on those debts to really try to squeeze our clients who own the mobile home and are having a financial hardship. And that could be an opportunity for us to, assert their rights and, find an unfair trade practice that we can go after the lender for.
Dan, excuse me, this is Kelly. If I could just interrupt.
Absolutely, thank you.
For the attorneys on the webinar, I am launching the poll box now. You'll have 2 minutes to hit yes or no so that I can record your participation. Thank you. And Dan, please feel free to continue.
Great.
Thanks.
Oops. All right. Well, just remember that act does not cover all possible financial transactions, to buy a mobile home. I cite a case here about, if the buyer is getting money from a bank or a lender separately from the actual transaction to buy it, then the Vehicle Financing Act does not apply. But other usury laws might come into play at that point. And, you want to pay close attention to that. Is the lender licensed in Pennsylvania? What's the amount and how much are the fees that they're charging? Look into that as well, if it doesn't fall under the Vehicle Finance Act. And then, of course, there's rent-to-own agreements. This is a home, so of course there's going to be something called a rent-to-own. But just like in every other situation, with home ownership, you have to scrutinize what the actual terms of the agreement are. Is this a true lease with an option to buy at the end? And therefore the Vehicle Finance Act doesn't apply, and a landlord, instead of repossession, can go ahead and just, evict. Or, is this more akin to, a classic Pennsylvania bailment lease where, it's in name only that it's a lease, that the payments are really purchase payments, etc. And then, the Vehicle Finance Act would apply and its restrictions. Let me see if I can advance my slide here. There we go. All right. Brian's up next with a very important and confusing topic of taxation of mobile homes as real estate. Oops, there we go.
Thanks, Dan. My name is Brian Doyle. I'm an attorney with Legal Aid of Southeastern Pennsylvania. I primarily practice family law, so custody and domestic violence issues. But last year, Chester County Division of Legal Aid began a project with United Way of Chester County to help mobile homeowners appeal their property taxes. And this photo on your screen, I think, hopefully sums up the issue. So mobile homes are supposed to be taxed according to their fair market value, or the assessment that they pay. Their tax based on is calculated using fair market value. The home on the first slide was in the tax board's system as if it could be sold today for $23,000, but the actual value is a little less than $5,000. And what that means to the homeowner is they're overpaying taxes every year by about $600. So on the next slide is kind of an overview of what this issue is. They pay these property taxes. The tax is supposed to be based on the assessed value, and the assessment office of your county is supposed to calculate the assessed value using evidence of the actual value of the home. So once they've calculated that assessed value, it's not going to change unless an appeal is filed. So if the homeowner is aware that this process exists, they're aware of what their assessment is, and they're aware that they can appeal it, it's on them. It's their responsibility to come out to, in Chester County's case, Westchester, and file an appeal. For all other purposes, though, a mobile home is considered the personal property of the homeowner. And like other forms of personal property, it's going to be a depreciating asset. So a comparison is often made between a new car and a new mobile home because they're both vehicles, although we don't compare a mobile homeowner's home to a car directly to them, but for value purposes, they're similar. The mobile home, like a car, is going to lose a chunk of value as soon as you put it down, like the car is going to lose a chunk of value as soon as you drive it off the lot. And unless the homeowner is regularly...
Excuse me, Brian.
Sure.
I'm sorry. Some people are noting that you sound a little muffled. Is there any way maybe you could sit closer to the microphone or give that a try?
Let me pull it a little bit closer. Can you hear me any better now with it a little closer?
If anyone wants to comment in the chat box, I could hear him okay before, but they said it's a little better. Okay, well, I'll speak clearly and hopefully you can understand me, but slow me down if I'm not understandable. Oh, the headset. Let me try plugging in a headset. Can you hear me? Yeah, I hear you. It still sounds the same though. It doesn't sound like... I might have to change what my... Yeah, sometimes you have to kind of turn on the headset. Oh, if I unplug the camera.
Can you hear me?
Yes. Oh, much better. Oh,
much
yeah.
better. Thanks, Deb.
Thank you.
All right. So unless the homeowner is appealing regularly, they're going to be overpaying. Last year, we started this pilot project, and as a result of it, we saw in 2019, 177 homeowners are going to be saving $171,000 per year on their taxes, and we did the project again this year with United Way, and it's another 333 homeowners are going to be saving almost $300,000 per year in taxes. It's a big difference to these people. They're going to be keeping in their pocket every year about $1,000 per household, which we all know is a huge difference for folks. So moving on just to take an overview of the law, I think Dan covered a lot of these areas, but I'm just going to give you the citations to the statutes so you have it. I'm not going to read it to you. There's really two places that we're looking for assessment law. Title 72 is the general county assessment law, but that's going to apply to your first and second class counties. So that's your Philly and your Pittsburgh. The one that I looked at is Title 53, 8801. That's the Consolidated County Assessment Law. And I think I'm 2 slides ahead now at this point. And I'm not going to read these definitions to you, but I do want to point out some of the important points that I'm going to be talking about, these underlined elements here. The mobile home and manufactured home, that's the idea that Dan was talking about, that some things are and some things aren't mobile homes, and the court has to be able to figure out how to do these things. So I'll talk a little bit about how the court does that. The actual value, so how are we appraising these things? So for a traditional real estate, you're going out and you're hiring an appraiser to come in and tell you how much it's worth. But for mobile homes, we've been able to do it a little bit differently and well, a lot more easily, and so I'll talk about that too. And then that final element there that I just wanted to point out, because it's important, is that these homes are assessed separately from the land. We're only assessing the mobile portion of it. We're not assessing the land portion of it. In most cases that we've come across anyway, they don't own the land anyway. That's owned by the park, and so the homeowner is just paying the tax, the property tax, on the fair market value assessment based on the fair market value of their actual home. So a little bit about the procedure, again, just to sort of walk you through it. If somebody wants to file their tax appeal, it begins by filing what's called a notice of intention to appeal. And when I go to the next slide, you'll see an example of the one from Chester County. Your county has a window for filing. So in Chester County, it's May 1st through August 3rd. So that's the time frame when you've got to get all of your appeals in. Other counties, I think, extend it to September. So you'll want to, if you're doing these, check specifically what your deadlines are, but they vary from county to county. When the hearing is held, you're going to go in front of a 3-member Board of Assessment Appeals to present what you've prepared for your assessment. And if you have a problem with what the Board of Assessment does, then your recourse is common pleas, and then if you don't like what happens at common pleas, then the Commonwealth Court. So that's sort of the trajectory of one of these cases. And then the next slide, you'll just have an idea of what these forms look like. They're really simple. The one on the left here, sorry, it's so small. That's the Notice of Intention to Appeal form that was available through the Chester County website. We used that in 2019. It's pretty simple. Some of the information you'll have to go outside, but a lot of it can just come from the client, like the number of rooms or address and things like that. The form on the right is a new form that Chester County came up with just at the beginning of 2020 because of all the issues, I guess, the volume of cases we were throwing at them caused. And this one allowed the homeowners just to do a simple depreciation request. So what are mobile manufactured homes? Now, I'm not going to spend a whole lot of time on this because Dan covered it very well, especially with the citation to Lance, where there's like a step-by-step factors analysis that the court can go through to determine it. But starting out with the same place Dan did, the pointing to the statutes, and I'm always a big fan of when a definition points to other definitions so that you can figure out what it is talking about, and that mobile homes kind of do that too. Some of the cases start with the Manufactured Home Community Rights Act, the citations on the next slide, which defines a mobile home by pointing to 2 places. The first is the federal law, the Manufactured Home Safety rules, and then the second is the vehicle code. So in the next slide after that, so I'm 2 slides ahead now, it's the definition from the federal law. I'm not going to read it to you, but there it is. It's basically you know, your 60 by 14 that can be transported on the back of a trailer, and it's placed down. You can hook it up permanently when it becomes considered real estate. So the vehicle code points again back to the federal law, and then essentially what I just said, it goes on the highway just for the purpose of putting it where it's going to be placed. And then the next slide, the last of this section, is a couple examples of cases that have that our Commonwealth Court has been asked to interpret what is and what is not considered part of a mobile home. And these are 2 pretty important ones I've found. This first one came up in some of our appeals. It's what gets included in that value. And in this one, we were talking about improvements to the land. So we're saying if the mobile homeowner constructed a garage or a deck or a shed, who pays for those? Is it the landowner or the homeowner? And this is the Douglas Village case, which if you ever wanted to see Lance factors applied. You can read the lower court opinion. But the Commonwealth Court said that these things aren't mobile homes, that a mobile home is synonymous with mobility. That's the whole point of it. These things are not mobile. They were permanently attached to the land. You couldn't move this deck without pulling up the concrete foundation. You couldn't transport it with the home without damaging it, so it's not going to be a part of it. So we were actually able to keep a lot of decks, sheds, outbuildings out of the values of mobile homes because this is our authority to do that. The second one, which is also an issue that came up this year, is when does this home transform from a mobile home to a non-mobile home? Because that's a concept that's been thrown around in some of the case law, is that these things, they start out as mobile, but you can do things to them that mean they're no longer mobile. And one of the most important things that you can do is you can attach it to a permanent foundation. So in this case, Chivarella, the homeowner, was trying to place a mobile home and then permanently attach it to a foundation. They got rejected for their permit because they weren't zoned for mobile homes there. He appealed, and the Commonwealth Court said the things he was doing to this home was going to transform it. You weren't going to be able to move it anymore. It was going to be permanently attached to this foundation. And because of these modifications, it's no longer mobile, and it's being transformed from a mobile to a single family home, and all the tax consequences that come with it. This came up in some of our appeals because some of, at least one mobile home community in Chester County, they've all got permanent foundations. And they're not valued as if they're mobile homes, so we can't use the same value methods that we've used in other kinds of homes, which I'll discuss next. So valuation, fair market value of mobile homes. Simply put, it's what the buyer will pay a seller on the fair market. And how do we get that value? We look to a few different places. The next slide, which I'm go to in just a minute, after discussing these first three, are the value reports, the bills of sale, and comparable properties. So we use almost exclusively the first two methods for our appeals. Mobile home value reports, and you see the two logos at the bottom of this slide here for the guides that we use. NADA and MH Village they're kind of like the Kelly Blue Book of mobile homes. You will put in your dimensions, your make, your model, some basic information about the home, and then it's going to give you a value that accounts for depreciation. Our board in Chester County was willing to accept these as the evidence of fair market value. We didn't have to go and dive too much deeper into it. When it would not apply is if we had a recent sale. If you have a recent sale within the past few years, especially, the bill of sale is going to be the most helpful indicator of fair market value. But even with that, our board was willing to average the two of them out, take our value report and the bill of sale, and give us the average of the two. Would they do that in your county? Certainly.
Oh, well, okay. So I don't know if this is the right time for this question, but how much is the valuation of the mobile home itself for tax purposes, including the location that the mobile home is at? And how do you, if you're getting a NADA guide assessment, it doesn't know, I mean, I guess it knows generally where you are, but it doesn't know if your park is run down or the rents are high or cheap or anything. So
Right.
How does that play in, if at all?
So that's something that you'd have to bring into it. Fortunately, when we were doing this project the past couple of years, we had one of our lead volunteers work for the health department. So part of what he did was visit all these mobile home parks, and he was very familiar with the different communities. And there is a field in NADA and MH Village that is park quality, and it applies a deduction or an increase depending on what you're saying your park quality is. But you're not going to know that if you're just meeting the client for the first time. And part of this project is volunteer involvement. It's a great, I guess, multidiscipline opportunity for people to get involved because you're going to need social service orgs. You're going to need volunteers to do your workshops. You're going to need attorneys to do hearings. There's lots of different opportunities for people to get involved. And if you have a volunteer from these communities or from a social service org that's familiar with the areas, you're going to have somebody who can say, this is probably one of the more rundown parks, or this is a better quality park. And that's what we were able to have, because a big part of this project and where I wanted to go with this whole presentation is how do you transport it to where you're located, because everybody's having these problems across the state because of the way the law is set up. So an important consideration is how do you transport, how do you bring it here? And that's, you got to find a location near your parks so that you're not asking people to come halfway across your county to get to you. And that's partnering with your social service or partners on this project who are familiar with these communities, who have the trust of the communities to actually bring people out. Because nobody wants to say, hey, save a whole bunch of money on your property taxes, it's not going to cost you a dime. They feel like they're being scammed. So this is kind of jumping ahead to how we manage a project, but you need good volunteers from your social service partners. I don't know if that answered your question.
Yep, thank you.
Okay. So fair market values, we're looking at the NAD reports, and I'll show you an example of those. I think I have a slide later that shows an example of it. But just turning to the law itself, this is a different section of the county assessment law. It permits us, it gives us authority to submit these value guides as evidence of fair market value. See, number one right there is you can submit your value guide. Number two is you can take depreciation into account. And then other factors, including how can you still transport this home? Is there another method of valuing it, like is it an income generating property, not so applicable to our cases? And is there any improvement made to the home? Because there are improvements that increase the value of the home itself, such that the value should be increased. Those things that are permanent additions to the home that you can't remove, those should be included. So the next slide is just photos of our value reports and a worksheet that we use to take into account present year's depreciation. So the sheet on the left is what you're going to create from the website. This one was NADA. It's run by JD Power. Your volunteer or whoever's running the interview plugs in the numbers, and then it's going to spit out a fair market value with your factors. I've written in there at the bottom plus features minus 2020 depreciation, because if you look at the second worksheet, our lead volunteers, I should say, have combed through the JD Power site, and they've come up with how much these standard features are worth, what the depreciation schedule is, so that we can make this a more efficient. And so far, our tax office hasn't had any problem with what we've been submitting. If you wanted to, JD Power also gives you options to go more into the nitty gritty and say what kind of, what's your voltage and what size is your water heater. But that didn't make a difference that was appreciable to what we were trying to propose. So you can do it in more detail, but this has been working for us. Okay, so how are we going through this appeals process? That's really what I wanted to get to after I laid all that out there is how do we get the clients involved? How do we run a workshop, and how do we get them in front of the board? So the first thing is, how do we get these clients? United Way has been an amazing partner for us, and my contact person there, Darshan, has said if anybody wants to try to transport this to their county, she'd probably be able to try to make some connection between us and your local United Way if you wanted that kind of help, or what kind of processes that they had in place. But anyway, engaging clients is number one, because as I mentioned a moment ago, there's a lot of distrust when somebody comes and offers you save a whole bunch of money. You're not going to do anything. There was one in-person workshop last year that we did where one of the residents came out and was, this is a scam, it's a scam, it's all a scam. So word of mouth is by far the most important way to get clients, in addition to all these other things that United Way was able to do, advertising, social media postings, and those sorts. But social service partners who are familiar with these communities is really what are going to bring the clients out. The workshops themselves, so it can be handled by a single volunteer, and we have all these materials. We have a process flow. I don't want to get into nitty-gritty of them, but basically they'd be completing the forms over the phone now. Pre-COVID, we would do them in person, but post-COVID, we've redesigned the process to do it all online. So they'll do a 20-30-minute workshop. The volunteer fills out all the forms with them, runs the fair market value through NADA, and then sends them the documents if they can receive them by an online signing service. So we used DocuSign, and then we used FormStack. Both worked equally well this year. The tax board didn't have any issues accepting them. And then you also need to submit with your appeal a notice, rather on the hearing day of your appeal, front and back photos of the home. So those are the United Way was able to find a volunteer to go and take those photos for us. Let's see, the board hearings themselves, very short. We got through over 100 a day. It felt like it didn't even take us through the morning. The board in Chester County, at least, was very receptive to this this issue. They had made a comment to us last year that mobile homes aren't getting a square deal, but it's not in the board's hands to go out and do anything about it. The board can't go out and do anything about it. If you're unfamiliar with this, it's called a spot reassessment, and it's an equal protection issue. You can't go pick and choose who you're going to apply the law to, so the board can't go out and change anything, but they recognize it as a problem. So they were very receptive in these past 2 years to accepting our appeals and getting these people a square deal. So, I'd encourage conversation with your tax office about how they want to do these things if you're looking to expand it, especially if you're looking to expand it to the volume of several hundred cases in a year, because they will not want to have a tidal wave just dropped on them like that. Clients don't need to go to the board hearings in Chester County, at least. I imagine every county is going to do it different, but in Chester County, I need to be mindful of my time, but in Chester County, they didn't need clients there for the hearings. So I'm more than happy to talk more about this project afterwards, or you can email me directly, but I wanted to speak briefly on tax sales. So one of the problems we found in 2019 is that people were coming to us and their house is already up for sheriff's sale. So that means they have had delinquent taxes from at least 2 years ago. So just quick, rough, broad brush approach to this. If you don't pay your taxes from past year, you're going to get a notice this year that says they're unpaid. If you still don't pay them next year, your house is going to go to sheriff's sale. If it goes to sheriff's sale, whoever buys it, it would come with those taxes. If it doesn't sell sheriff's sale, then it's going to be opened up to potential for a judicial sale in the following year, which is going to sell clear taxes. And Dan, you'll clear up any misstatements I'm making, but I think I have it right. Homeowners, besides challenging the sale, have a couple options. They can do an agreement to stay, in which case they put a quarter of the amount owed down up front. So they call the tax claim bureau, they say, I want to make a payment plan, and they put a 25% down, and then they have to pay the rest of the installments in quarterly payments. The second option, which I was trying to find the application, it's called a deferral of taxes. I didn't find the application before this, but you can file what's called the deferral. If you meet the eligibility requirements, then you can get a year's deferral, but it doesn't clear up the taxes.
Brian, I'm sorry, I hate to interrupt when you have a flow going, but I need to launch the second CLE poll and give you a moment to breathe, I think. So attorneys on the call, if you're requesting CLE credit, please respond to the question now. It'll be up for 2 minutes. Thanks. Sorry again to interrupt.
No, I get yelled at by court reporters all the time. You're talking to.
I'm totally not yelling. Feel free to continue.
I think that takes care of my sections, but really I would like to answer any. It's a big issue, and I've tried to just scratch the surface of it. But I want to, if this is something you want to help your clients with, at least you can give them the advice. This is an opportunity. But if you want to move it, a version of this project to your county, I'm happy to be a part of that conversation. I'm happy to bring our United Way in on that conversation, because that was really the goal. This is something that's affecting every mobile homeowner in Pennsylvania. And we can put a Band-Aid on it for now. So that's what we're trying to do, because you can see from the numbers I shared earlier, it's a huge difference to these folks. So any questions you have, feel free to email me, chat with me, call my office.
Yeah, I'll just say, you know, I got the numbers back on the screen. That's real money right there. That is a lot of money that was saved for people. So great job, and I encourage people to think about this in their own counties.
I'm not showing that we actually have any questions.
Okay, good. We'll move on to the next section. I will say at the conclusion, you know, remember, because this is it's taxed as real estate, then there's the whole, you know, if they are losing the property, they can challenge whether if they've lost it, they can go ahead and challenge whether the tax sale was proper. And, you know, that's a whole another day's training. But my general assessment is, if your property went up for tax sale and you get an attorney to scrutinize the sale, you could usually find a mistake. So it's worthwhile not just saying, oh, it's too late. If that's value to the person, and you have time to help them, then you can probably find a way.
Dan
Right.
and Brian, I'm sorry, we do have a question. I missed this because people are private questioning me. The question is, do you ever have realtors do assessments for you?
It didn't come up in my project.
Right, Brian, you would agree that that would be a good way to look at it, but they'd probably be looking at comparative values, right?
You know, I would
hard.
really love to see how a realtor comes out compared to an NADA. I haven't seen that yet. It hasn't been tested because they've been accepting our NADA values. But I'd be very curious.
Yeah, I would be too, to see if which one's getting the better deal for the tenant on this situation. All right, so we're just good. I guess we're at time. So I'll just remind folks that, you know, there are issues once, you know, these are mobile homes. They're mostly located on a rental lot in a mobile home park. But the home itself is valuable. It's like most people, right? Your home is your best asset, your biggest asset. And even old homes can be worth more than people would expect. I know a lot of homes are transferred for $1 or, you know, just, you know, pay the taxes kind of stuff. But I also find homes are transferred for quite a bit of value. You know, a $10,000, an old home you buy for $10,000 spread out over some time is a pretty low payment. So if you're evicted from the lot, you shouldn't have to lose your mobile home. Essentially, you know, the eviction does not control the, you know, who possesses the mobile home itself. You can't live there. You've been evicted from the lot. But my position is you still should have the ability to sell the mobile home and to return to the mobile home, to remove your stuff, to winterize it, to prepare it for sale, and to show the property for sale. And, you know, a landlord is going to be able to charge for you having the mobile home on their property, storage fee, probably equivalent to the lot rent. And if they're savvy, they might go ahead and try to levy on the mobile home itself if they've received a monetary judgment as part of the eviction action. So I encourage people to look at challenging those levies as excessive for a home that could have some resale value. And hopefully you can get the levy removed from the actual mobile home so the owner of the home can go ahead with the sale. There is a process to the sale we just talked about. And the buyer should be given notice of the lease terms, the rules and regulations, and the fees in the park. But what we often see is the owner trying to interfere with that sale. And the state the state statute that regulates mobile home parks, it expressly says you can't have any conditions regarding the sale of mobile home parks as part of the lease. The owner cannot unreasonably deny approval of the buyer as a resident in the park. That's a big one that, you know, they want to say, they do have the right to say, you know, I'm not going to approve everybody. They have to go through the process, but if a potential buyer would otherwise be eligible, they can't just be unreasonably denied by the owner. And you see that a lot as a way for the owner to make money, because the owners make a lot of money off getting these mobile homes when the tenants just give them up, right? And there's no fees that can be charged by the park owner unless they're actually involved in the sale as a licensed agent. And this could be this could be a good claim against the owner for unfair trade practices and treble damages if they're interfering with the sale of the mobile home. But it's really a great way to get value from your asset if you've fallen on hard times and failed to pay your rent or whatever reason you were evicted from the park. And then the last thing I'll touch on is abandonment of mobile homes. There is a process by which a park owner can go through the court system to have a mobile home where someone's been evicted from it, declared abandoned, and then they can, sell the park or sell the mobile home, transfer it, destroy it, etc. But remember, there is a specific process for how it gets determined to be abandoned, and then what the landlord has to do in order to go through and either demolish it, or to put another home on the lot, or to rehab it and sell it, etc. There's a very specific process, and so if the landlord is not following that process, then they're converting your client's property, which again could be quite valuable. So something to stand up for your client, help them out if they're already evicted and they really need that money to pull that money out of their mobile home. All right, that's it for us. Thanks for an hour of your time this morning. If you have any questions, feel free to email Brian or myself. We welcome the questions.
Thanks, Dan and Brian, and everybody have a great day.
Take care.
Thanks,
Take
everyone.
care.